hello everyone who's coming in and joining. We'll allow a few minutes for everyone to get into the webinar, but thanks for coming. We'll start very shortly. We'll allow a few minutes for everyone to All right, everyone, we'll just get started now, and thank you so much for coming. This is, of course, the renters' rights workshop and explanation of resources to talk about navigating fair housing and the impending end of the eviction moratorium, how you can find help with utilities and rent in Pittsburgh and in some cases in the surrounding area. So my name is Jam Hammond. I work for the Pittsburgh Commission on Human Relations, which is the civil rights enforcement agency for the city of Pittsburgh. We do enforcement in employment, public accommodations, civil rights, so civil city services, and also in housing. And I'm lucky to be joined today with quite a few representatives from our community of housing advocates and housing community organizations. So I'm really happy to be here. Just a note, if you do need to access the Spanish translation or Spanish interpretation services, there is a phone number that you can call to find it. Saunders has just posted it in the chat. And if you need to get Spanish interpretation, that's how you will be able to get it. So call that number. There are a few instructions and you'll be able to listen in Spanish. You are also able to use the Q&A feature. So if you have any questions, feel free to submit the questions in the chat. We will have some time at the end of each presenter and also at the end of the webinar for live answering of questions. But any questions that you might have now, feel free to put them in the Q&A and we'll do our best to answer them as we go along. So we'll just get started with some of our community organizations. And some of the first things we'll be talking about are legal topics. So this will deal with first the federal eviction moratorium and the utility moratorium. So let me, 1 second. You can also get this live on Facebook. So I'll put that link there too if anyone wants to share it. I think that we're having some difficulty getting our panelists from Regional Housing and Legal Services in, but we do have somebody from Pulp, Gio Brackbill. So we'll get started with Pulp, and then I'll do my best to try to get our panelists from Regional Housing and Legal Services in.
Good afternoon. I'm Gio Brackbill from the Pennsylvania Utility Law Project. I'm happy to be presenting to you today. I'm going to start with an overview of the moratorium timeline. If you've been paying attention to what's been happening over the last year with COVID, on March 13th, 2020, the Public Utility Commission issued an emergency prohibiting regulated electric, natural gas, water, wastewater, telecommunications, and steam water utilities from terminating customer service during the COVID-19 pandemic emergency. Then on August 10th, the PUC issued a letter from Chairman Duterte requesting comments regarding the moratorium and customer protections for at-risk customers, and if the PUC lifted the absolute service termination moratorium. Then on October 13th, they did lift the absolute ban on utility service terminations, and they allowed terminations to begin on November 9th, 2020. Something that's very important with this order that they released on October 13th is that protected customers will remain protected from termination until March 31st, 2021. Now, there's some things that protected customers have to do to obtain that status, and we'll talk more about that definition. Essentially, they need to apply for available assistance programs and request a payment arrangement from the utility. And on the next slide, these are also some things that you need to be prepared for if your clients or you are receiving shutoff notices. There is special outreach and notice to customers at risk of termination above and beyond the normal notice that they're given. And there's no terminations for protected customers until March 31st, as I mentioned before. Payment arrangements for small businesses is another thing that rolled out with this order. And then there's no connection or reconnection fees. They're going to be waived. And then there's no late payment charges for protected customers. Additionally, there's extra medical certificates. So there's 2 extra certificates, and they're going to be accepted by utilities for eligible customers who exhausted the number otherwise available. And there's an additional 7 days for medical professionals to return the certificates to the utility. And then lastly, there's going to be flexible income verification. So they will be accepting verification of clients' income over the phone or email. Sometimes that even involves like using a cell phone to take a picture of someone's pay stub and sending that in over email just to make it easier for customers. Next, with regard to the special outreach and notice that I discussed, the October 13th order is requiring them to inform the customer that they're at risk of service termination and give a general time frame for when service will be shut off, and inform the customer of available options. They must send that at least 10 days before sending the standard 10-day termination notice required by the PUC regulations. And then
So sorry. The Spanish interpreter has asked, and I forgot to mention that we should try to speak a little bit on the slower side, just to make sure that they can catch everything we're saying.
My apologies, Jam. I'll try to slow it down.
No problem. Is it next slide?
Yeah, so next I will be sharing the definition of protected customers. Again, protected customers cannot be shut off until March 31st, 2021, but they must meet the following requirements. First, they must be residential customers. They have to have an income at or below 300% of the federal poverty income guidelines. You can see that chart below. It's the third column to the bottom in the right. You'll see the 300% federal poverty limits. Next, they must request a payment arrangement from the utility, which means that they have to call the utility in order to obtain this status and request a payment arrangement. Then they must apply for all available assistance programs if eligible. The utilities, again, must waive the late charges, reconnection, and deposit fees for protected customers. Next, I'm going to discuss the USEPs. So that would be the Universal Service and Energy Conservation Programs. All of the large regulated gas and electric utilities are required to have these programs, and they're designed to assist low-income households in order to maintain affordable service. So when protected customers are calling their utilities, they need to ask about these. First is the Customer Assistance Program that will help reduce bills and arrearage forgiveness. Next would be called LIARP, or the Low Income Usage Reduction Program. That would be weatherization and energy efficiency to help cut down on those costs. And then there's the CARES, Customer Assistance, Referral, and Evaluation Services. This involves case management and referral to other social services reports. And then last but not least, we have the hardship funds, which involves grants to help pay those bills. So this is very important if you are a tenant with a utility in the landlord's name. This is how to prevent utility terminations. If the utility is in the landlord's name and the landlord doesn't pay, a renter must be provided 30 days notice before the utility can terminate. The renter must be given an opportunity to continue service by paying just the last 30-day bill. And the renter must be allowed to pay utility bills going forward and deduct that from their rent. The renter has protection if the landlord tries to retaliate, and lease waivers are prohibited. So the landlord can't ask a renter to waive this right. If a landlord voluntarily requests to cut service to a tenant property, the utility must require a notarized document swearing under penalty of law that the property is unoccupied. And unregulated utilities fall under the Utility Service Tenants' Rights Act, or USTRA, and then regulated utilities fall under the Discontinuance of Service to Lease Premises Act. We just provide those in case you're advocating for someone so that you know where you're citing to. Also, regulated utilities are required to observe the protections from foreign load. So foreign load is where a tenant is paying for service rendered to another unit or common area. So if a client believes that they're paying for, it could be a light in a common area or the washer and dryer in the common area, they can call the utility and report that. The bill will automatically be transferred into the landlord's name, and then if it's found that they are paying for that foreign load, it won't be switched back into their name until that is solved. Last but not least, I'm going to go down through a list of general advice. So if you don't take anything else from me, this is what I want you to remember. Call your utility and inform them that you're a protected customer and provide the income information if required. To avoid shutoff, you need to apply for those low-income assistance programs and hardship fund grants, even if you didn't receive a notice or letter from your utility, my apologies. Third, request a payment arrangement, but this is very important. So when you call your utility because you receive a shutoff notice, you don't have to agree to a payment arrangement. In fact, if you can't afford what they're offering you, you always have the right to say no. If there's a dispute to the amount owed, if you look at the bill and you're like, this is not right, don't agree to a payment arrangement to pay that off, because then you'll be bound to pay it. Also pay what you can when you can, because when a lot of these programs, the assistance programs, they want to see good faith payment history. So it doesn't matter, even if it's $5 that you paid per month for the last 3 months, that will actually help you to qualify for more programs and grants, because it shows that you're trying. If you're a protected customer who's having issues and proving that you should be protected, you need to file a complaint with the Public Utility Commission at least 24 hours before you're shut off. And last, apply for the LIHEAP program. That's Low Income Heating Assistance Program. You should do that right now because it's open. Also, I just want to point out that we will be sending some resources and supplying them to you afterwards if there's any questions about anything that I discussed.
Thanks, Gio. Yeah, that's really helpful.
Thanks, Jam.
Yeah. And so I know we also have legal resources to talk about. Let me go back to those before we go on to our rights section. I believe Bob is here from RHLS.
Yes, I am.
Okay, great. Bob, ready for you.
Okay, thank you. Please move to the next slide. Okay, so like Jam said, my name is Bob Damewood. I'm a staff attorney in the Pittsburgh office of Regional Housing Legal Services. RHLS is a statewide legal aid program, and we represent community-based nonprofits that are developing affordable housing. And we also engage in advocacy efforts on behalf of low-income Pennsylvanians statewide. So I'm going to talk about three things today. This is the state of, this is where eviction moratoria are now as of today. Things change on a monthly or even a weekly basis, and hopefully things will change soon. But right now, tenants have three protections, COVID-related protections. One is a pair of administrative orders by Allegheny County President Judge Kim Berkeley Clark. Another is the CDC, Centers for Disease Control, entered a temporary halt to eviction order on September 4th that halts certain evictions and through the end of the year. And then there are still some CARES Act protections that are left over, even though their moratorium has expired. And that moratorium may get renewed, hopefully. But I'm going to talk about all three of these things. Okay, so the Allegheny County administrative orders. Just less than a week ago, a new administrative order was issued that postponed all landlord-tenant hearings, all eviction hearings in magisterial district courts until after January 8th. So I know that a number of housing advocates and others are advocating to have that order extended or to have a more comprehensive moratorium in place at the county level. And hopefully those efforts will be successful. But right now, eviction hearings are on hold until after January 8th in Allegheny County. There's also an earlier administrative order from September 4th. And, so after, assuming no county moratorium is put in place after January 8th, and assuming the CDC order isn't extended and there's no other, state or federal moratorium in place, then this provision of the September 4th administrative order would kick in, where if tenants are being evicted for non-payment of rent, they can tell the magistrate and the landlord that they would like to apply for rental assistance, and the magistrate will then change the hearing to a status conference to discuss that, that possibility. Next slide, please. So the CDC temporary halt to evictions, this went into effect on September 4th and it expires at the end of the year. Again, hopefully it'll be extended and fixed. But essentially it halts certain evictions, which I'll get to in a minute. In order for that halt to kick in, the tenant and all adults on the lease must sign a declaration and either deliver that declaration to their landlord or provide it to the court if they're being sued for eviction. And the link to the declaration is on the slide, and it was just posted in the chat. So unfortunately, the CDC order does not halt all evictions. It halts some. It halts evictions for non-payment of rent, and it halts some evictions for end of lease term. Some of that is still up in the air. There's an open question about which end of lease term evictions are halted. But in Allegheny County, at least, Judge Hertzberg has ruled that, at least in one case where it was clear that the eviction was for end of lease or was for non-payment of rent, but the grounds for eviction were end of lease term. So the reason the landlord refused to renew the lease was because the tenant was unable to pay their rent. In that situation, Judge Hertzberg found that the CDC order applies and that the eviction will be stayed once the tenant provided that declaration to the landlord. So what actions are prohibited? The CDC declaration or the CDC order is really directed at the landlord, not at the courts. And so the CDC order says that the landlord may not take any action to cause the removal of a tenant household. They've interpreted that to mean actual eviction so actual lockout. So if the landlord takes that action in violation of the CDC order, then that subjects the landlord to criminal penalties. But according to Allegheny County's September 4th administrative order, the courts will also honor the CDC order in the declaration. So if the courts if a judge learns that the tenant has provided the declaration to the landlord, or if the tenant provides the declaration to the court in the context of an eviction proceeding, then all eviction proceedings will be stayed until after the CDC order expires. And right now it's set to expire on January 1st, but again, hopefully it will be continued, it will be extended. Next slide, please. I'm not going to go through all the statements in the CDC declaration. You can see them if you click that link, but there are two statements that refer to the tenant's best efforts. One is, the tenant states that they've used best efforts to obtain all available government assistance for rent. And the other is the tenant is using best efforts to make timely rental payments that are as close to the full payment as the tenant's circumstances may permit, taking into account other non-discretionary expenses. So, it's worth discussing what best efforts means in terms of those two statements. There's all kinds of court decisions describing what best efforts means in different contexts. But essentially, it doesn't mean doing everything imaginable. It means doing everything that you can reasonably be expected to do under the circumstances. And so, tenants are allowed to act in their best interest and in their family's best interest while using best efforts. So it doesn't mean your kids have to go without, Christmas presents, doesn't mean your kids have to go without school supplies or clothes or anything like that. Doesn't mean you have to not pay your utilities in order to pay your rent. It doesn't mean if you have a retirement fund, it doesn't mean you have to, raid your retirement fund in order to pay your rent. There's a reasonableness component to what best efforts means. So essentially, tenants should pay what they can reasonably pay after looking at all of their expenses. And tenants know their expenses better than anyone else. It's clearly tenants and landlords are going to have different ideas of what best efforts means. But as long as, if it's challenged in court, as long as you can go to court and explain how you came up with, what you can afford to pay. And as long as you're able to show your other expenses, you should be fine. You don't have to, deprive your family of other essential things in order to pay your landlord under best efforts standard. And next slide, please. So some practical advice. First of all, there's only 3 weeks left on the CDC temporary order, but it could be extended. And so, if the declaration applies to you, use it. Definitely sign the declaration, give it to your landlord if that's what it takes to avoid being evicted for non-payment of rent or end of lease term. Secondly, keep a copy of your signed declaration because, you might have to show a court that you gave it to your landlord. Be able to prove delivery. So, you can mail it first-class mail with verification of delivery. You can scan and email it. You can take a picture of it with your phone and text it or email it to your landlord. But be able to prove to a court that you delivered this to your landlord if necessary. Apply for rental assistance first. And Abby Ray is going to talk about that in a minute. Offer your landlord at least some partial payment. Again, not more than you can afford, right? Don't set yourself up to fail, but offer something. And then finally, in case the landlord challenges your declaration, be prepared to show a court your income and expenses. To show that you're paying everything that you can reasonably be expected to pay. Next slide, please. And then finally, there are certain CARES Act protections left over that apply to federally assisted properties. And now this is important because, Congress is considering a new COVID relief package, and that may include another, moratorium, another federal moratorium. But it's important to keep in mind that the federal moratorium in the CARES Act wasn't across the board. It didn't apply to all properties. It only applied to federally assisted properties. And so, if there's another moratorium, most likely it will only apply to these properties as well. And then the protections that remain in the CARES Act only apply to federally assisted properties. So what are federally assisted properties? They are properties that either have a federal subsidy. So, that can be low-income housing tax credits. It can be, a Section 8 subsidy, whether used by that tenant or by other tenants in the property, it doesn't matter. If that landlord receives a subsidy for that property, then all tenants in the property are protected. And it could mean that the property is subject to a federally backed mortgage. So a mortgage by the Fair Housing Administration, the Veterans Administration, USDA, Fannie Mae, or Freddie Mac. There's a database of properties with federally backed mortgages. It's not 100% accurate, but it's close. And so there's a link to that in the slides. Please, if you're subject to, if you think you're going to be subject to eviction for non-payment of rent, absolutely check to see if your property is on that list. Essentially, before a landlord can file an eviction action in Pennsylvania, they must file an affidavit of compliance with the CARES Act. So it means that the property is not covered, or if it is covered, that the landlord has done, that essentially the CARES Act prohibitions do not apply. If the CARES Act provisions do apply, there are two potential protections. One is if there's a mortgage that is in forbearance on the property, the landlord cannot evict for non-payment and cannot charge late fees during the forbearance period. And finding out whether a mortgage is in forbearance, you essentially need to litigate that. You need to have a lawyer. It's very difficult for a tenant to find out whether their landlord's mortgage is in forbearance. And secondly, the other protection is a 30-day notice to quit is required for all properties, whether it's in forbearance or not. If it's a federally assisted property, then a 30-day notice to quit, eviction notice, is required for non-payment of rent before the landlord can file an eviction action. And then finally, last slide. Okay, I've listed a few resources here. Neighborhood Legal Services can provide eviction defense. And so there's their contact information. For more tenants' rights. So tenants, even if they're not subject to a moratorium, even if the eviction isn't stopped by a moratorium, there may be defenses that tenants have to an eviction that I just didn't have time to go into in this presentation. But you can find a good overview of the various eviction defenses and possible counterclaims at the PA Law Help website, and that link is in the resources. To get involved in advocacy around the various moratorium efforts, please, feel free to call the Pittsburgh Union of Regional Renters, and their phone number is in the resources. And then finally, if you have any questions, feel free to send me an email, bob@rhls.org. And thank you. Hopefully I didn't speak too quickly for the interpreter, and I'd be glad to answer any questions.
Oh, thanks, Bob. That was great. I'm not sure if this is one that you can answer. I know we'll also have Abby Ray later. Somebody posted, since CARES RRP isn't currently available, are there alternatives you folks suggest?
Oh, for rental assistance, I think that's an Abby question.
That probably would be. But that's a good question. Yeah, if anyone has any questions specifically for Bob or for Gio, who spoke earlier from Pulp, you can post them in the chat. I'm sorry, in the
Well,
Q&A. Go ahead, Bob.
I do see some questions in the chat. One is from Abby Ray. So for federally backed units, is this 30-day notice to quit still required even if the notice is waived in the lease? And absolutely yes, it is. It is a requirement, a CARES Act requirement that applies to all federally assisted properties. So if it's got federal subsidy or a federally backed mortgage, then a 30-day notice to quit is required. And then Helen asks, what is the status of NLS funding? Can they represent any tenant being evicted? And I don't know the answer to that, quite frankly. I mean, you have to reach out to Neighborhood Legal Services to find out. They provide eviction defense in some evictions and not others, and in some courts, certainly in the Court of Common Pleas, not usually at the magistrate level. Please call their number anyway. It doesn't hurt to call and find out.
Yeah, I will say that Neighborhood Legal Services was our partner in the first of these webinars back in, I believe it was August or July. So that would lead me to believe that they are still covering eviction in their services. But again, I would, yeah, of course, reach out to them specifically.
Oh, and one final thing, and then I'll shut up. Amy Carpenter with Neighborhood Legal Services corrected. I had a typo in their phone number, and I apologize for that. But in the chat, she corrected it. It's 412-255-6700.
Yes. Yeah, thank you, Amy. All right. Well, if there are, and of course, we can continue to answer.
Yes.
I'm not.
What?
I'm not stopping.
Of course, continue to answer questions in the Q&A, but we'll move on to talking about rights. I believe it's the next section. And for that section, first we're going to go to the Fair Housing Partnership of Greater Pittsburgh. I believe we have Megan Confer-Hammond on. Hello.
Sent you something about some woman who wrote me.
Hang on 1 second. I'm going to get this. There we go.
Thank you very much, Jam. And so my name is Megan Confer-Hammond. I am the Interim Executive Director at the Fair Housing Partnership of Greater Pittsburgh, and we deal with housing discrimination. So separate from the Landlord-Tenant Act is that discrimination is a separate law that provides protections on the basis of what's called protected classes. And Jam, if you can go to the next slide, please. So to simply do a quick overview in understanding how the law defines what discrimination is, simply understand the protected classes, which are race, color, national origin, religion, sex, disability, and having minor age children or a pregnancy in the household. Now recognize that housing discrimination requires that the act of harm that happens against you in housing is related back to the protected class. And the next slide, Jim. Further understand that in the city of Pittsburgh, there are additional protected classes that you can use as a basis for making a city-based complaint. So always recognize in the number of laws that we're discussing, what law you're accessing and where you need to go in order to get your rights in that law. At the federal level, you can contact the Fair Housing Partnership and the Commission. And then at the city level, you can also contact us, and any cases that move forward will happen within the city ordinance. And so in the city, place of birth, sexual orientation, gender identity, a status as a survivor of domestic violence, citizenship and immigration status, as well as language use, is protected against unfair actions by the landlord because of that status. Next slide, Jim. So simply recognize, we won't get deep into the legal theories, but recognize that the most common type of discrimination case is based on treatment, where a landlord is acting illegally or wrongly, such as charging additional fees, denying housing because of who a person is. And so as long as we can show that the landlord's bad actions is based on the identity of the tenant and who they are, then there is the potential to move forward to make a legal case regarding housing discrimination. Next slide, Jim. So to speak specifically to some of the aspects that we're seeing during this era of COVID-19, recognize that national origin is a protected class. And so simply to touch base, because the spring seems like it was a lifetime ago, is that when COVID-19 was originally identified, the World Health Organization quickly created the name COVID-19 because it is policy that no disease is connected to a group of people in any way at all, in order to avoid discrimination and stereotypes against that group of people. So recognize that xenophobia or discrimination based on being from being Asian American, being a person of Asian descent, that the virus, while identified initially in China, is not at all related to the identity of who people are, such as, for example, their national origin. So any treatment by a landlord based on, being Chinese or of Asian descent or of any other national origin is absolutely illegal and prohibited, in fact, by federal law, that cannot be the basis of a landlord's actions. Any actions by landlords about COVID-19 must be based on science, must be based on facts, and must apply to everyone. Next slide, Jim. Also recognize is that while we are largely staying at home as much as can be possible, that there are a lot of social interactions that are boiling over. And so the Fair Housing Act provides protections from harassment. The harassment can include tenant to tenant when it's based on a protected class. So if another tenant is yelling racial slurs or attacking you and your family because of who you are, then you need to tell your landlord that the other tenant is harassing you because of who you are, this protected class. And then the landlord has an obligation to act or to intervene. Also recognize that landlord to tenant harassment, again, we continue to go back to the protected class, that a landlord cannot harass you or treat you differently, require the rent before everybody else, charge more rent because of your identity. And again, just to be clear, is that if another tenant is harassing you as a tenant, to report it to the landlord, and to be clear that it's based on your identity. Next slide, Jim. Also recognize that under the pandemic, we can look at COVID-19 as potentially being protected within disability under the Fair Housing Act. Recognize that disability as defined by the Fair Housing Act is the most broad definition of disability within federal law. And so when it was added to the Act in 1988, it was written at a time during the AIDS, HIV epidemic. And so having COVID-19 and being treated differently because of that diagnosis that's not based on facts, but is based on stereotypes and fear, is potentially discrimination. Additionally, if you are an essential worker, for example, working at a grocery store or other service industry, and you're perceived to have COVID-19 because of your exposure to the public, because of your inability to stay home, there is also opportunity to look at it as a housing discrimination claim. If your landlord is treating you differently, not renewing your lease, trying to evict, solely because of their fears based on their perceived concept of you being exposed to COVID-19. So certainly report these. This is a new space within the Fair Housing Act, but there is case law on there. There are ways to make these facts to show that landlords must act based on facts, based on knowing you have COVID-19, based on making accommodations. And so another piece is understanding reasonable accommodations. That's a change to the rule because of having a disability and a disability-based need. So when you look at COVID-19, assuming the person does have COVID-19, you can look at how can the threat to the public safety and the safety of the property and the people in the property be protected. So allow for quarantining within the unit, allow for providing hand sanitizer and masks to the tenants. So there's ways that landlords can react with facts to facts, not based on stereotypes and fear mongering. And remember, is that if there is a new rule because of COVID-19, such as no outside guests, and a person with a disability has an aide or caregiver who comes in, then the landlord needs to engage and find a way to allow such a caregiver to come in safely. Next slide, Jim. And I want to touch on this topic for a moment. So within reasonable accommodations, emotional support animals are covered by the Act. So if a person has a disability such as mental health, schizophrenia, bipolar, depression, anxiety, we all understand that you can only go to therapy so many times a week. You can only take so much medication. And emotional support animals are massive help and support to assist people with disabilities in living their life to the fullest and in mitigating those symptoms of panic and fear. But it's important to understand your obligation in order to request an emotional support animal. Given that pets have become so popular during the pandemic, we're also seeing an increased request for emotional support animals. And so recognize that you do need to be a person with a disability and that you do need third-party verification. While it doesn't have to be from a doctor or a licensed healthcare professional, it does need to be reliable from someone who can speak expertly about your disability-based need for an emotional support animal in order for it to be required that your landlord allow you to have your emotional support animal in your property. Recognize how controversial ESAs are right now, and that last week, the Department of Transportation issued a new rule that ESAs are no longer required to be allowed on airlines. And so emotional support animals are absolutely covered by the Fair Housing Act, but you must protect yourself and meet your obligation on what you need to provide in order to be protected by the Act as a person with a disability who is asking for such an animal. Also recognize that with the pandemic, there is a space regarding accommodations about leases. And so, for example, people needing to be released from a lease in order to live with caregivers or other support systems. And also in situations we're seeing that given the public health nature of the pandemic, that lease non-renewals for people with disabilities can put people with disabilities into a public space that is not safe at this time. So again, there is a lot that we are learning as we go, but please report, if you believe that you think that any of this applies to you, and we will work through the facts to determine, what is possible within the Fair Housing Act. A couple more slides. Next slide, Jim. Simply understand, we all understand that Pittsburgh and the Western Pennsylvania is heavily racially segregated. And so the pre-existing inequities that we have, especially based on race and national origin and other protected classes in which we are more likely to be in poverty because of that inequity, is only being worsened by the pandemic. From a fair housing side, we are doing all that we can on policy and rulemaking in order to address those inequities, not equality, but inequity, to help get us all into a space of having a fair shot. Next slide. And also remember is that sex as a protected class includes sexual harassment and domestic violence. Sexual harassment has been a priority of the Department of Justice, And in November in 2020, there was a $49,000 settlement in Indiana with a landlord who also agreed to cease all contact with tenants. And so we have a robust relationship with our local Department of Justice and for pursuing such cases as people come forward with those reports. They are complicated to investigate, but we are committed to pursuing every fact that we can in order to make sure that justice is served for landlords who engage in such behavior. And also with domestic violence. And so as we are forced to shelter in place, survivors are unable to access resources. And so if you are a survivor of domestic violence, there are fair housing protections for what needs to happen to have your abuser removed from the unit, or if the survivor needs to leave the unit. And additionally, nuisance ordinances or other policies that would prohibit a survivor from feeling comfortable to call in the police when necessary because of violence and abuse can also be discriminatory under the act. So please, please, please certainly report such instances and you can contact us via our website or telephone or email in order to get these facts across, to let us know so that we can investigate. And the next slide, Jim. And so again, and I'll turn it over to the commission. And so simply understand the difference between the Fair Housing Partnership and the Pittsburgh Commission. We are partners and we collaborate. FHP is your advocate. We will help build and develop your case and assist you in the filing process and advocate on your behalf during that filing process. The commission is the fact finder who determines whether or not discrimination happened within the law. And that is where complaints are filed in an administrative way. And so you're free to contact both of us or either one of us to go through your facts and to receive that help in enforcing your fair housing rights. So stay safe out there, everyone. And I'll turn it over to the commission.
Thanks, Megan. And we'll go right to Rita Porterfield, who's our housing investigator, or the main investigator for our housing complaints. And if you have questions for Megan from FHP or for Pittsburgh Commission on Human Relations, please do put them in the chat or Q&A. We're going to probably skip the question section just for this section, knowing that we're a little short on time. And then I'll turn it right over to Rita.
Good afternoon, everyone. My name is Rita Porterfield, and I'm the housing investigator. I also investigate other cases, but primarily housing. And as Megan said, we are the investigative arm of discrimination, and we investigate not only housing, but employment and public accommodations discrimination. Public accommodations, some examples of those include going to a store and not being served because of a protected class status, such as race or disability. So public accommodations are businesses open to the public, generally speaking. For a case to come before us, it needs to be reported. If you have any doubt, if you've been discriminated against on a protected class basis, please come talk to us. Our intake office with Jam is particularly amazing. He will take the time to figure out if there's a case, and I will take the time to investigate that all the way through. And there are 2 other capable investigators in addition to myself and lots of wonderful support staff. For us to take a case, the discrimination must be based on protective class, have occurred within the physical city limits of Pittsburgh, and happened within the last 365 days. Once we get a case, we make the investigation, and as part of investigation, I talk to witnesses, parties, respondents, if they have attorneys, if they have representatives available. Once I finish my investigation, and that may include collecting documentation in addition to conducting interviews, I write a report, the independent commissioners vote on it and determine whether it's likely there was probable cause of discrimination or whether there was not probable cause of discrimination. If a case goes probable cause, the next step is to attempt settlement at what's called a conciliation. If that does not work, then there's a public hearing. And at that time, witnesses can be called and the commission brings forth its case and its findings. And I just want to emphasize what protected classes are in the city of Pittsburgh. There's ancestry, citizenship status. We don't ask an investigation whether or not you're documented or undocumented. We will help you regardless of citizenship status. We will help you regardless of preferred language. And if we need translations, we will. And to emphasize, hablo muy poco español, pero quiero que sepas que estamos aquí para ayudarte. We're here to help, and I want you to know that we're here to help. We also have in place, in addition to preferred language and citizenship status, which are new protections, we have hair protection. So hairstyles, hair ornamentation, head wraps, or other headdress. And lastly, retaliation is a protected class. So if you cooperate with us, no one can retaliate against you in housing on the basis of cooperating with the commission. So I hope that makes clear what we do and that it is broad powers. Next slide, please, Jan. Some examples of what it is illegal to do. Someone cannot refuse to rent or sell housing based on your protected class status. They can't refuse to negotiate renting or selling housing. They can't deliberately make housing unavailable. They can't set different terms, conditions, privileges for sale or rental. For example, we've seen some cases on a national origin or citizenship basis where persons without Social Security numbers were being charged more rent or more security deposit than those with Social Security numbers. Landlords and housing providers cannot provide different services or different facilities to different people. Housing providers cannot lie that housing is not available when it is. Housing providers cannot make, print, or publish, and that includes on social media, discriminatory statements about housing. Housing providers cannot use different qualification criteria for different persons. Again, the example of the Social Security numbers or not having them is different qualification criteria. They cannot harass a person either because of their protected class or because of their involvement and cooperation with our commission, and they cannot fail or delay in the maintenance or repairs of the unit. Next slide, please, Jan. Last year, if we can't help you, we try to get you to someone who can help you. So we referred 12.5% of our inquiries to other agencies for more help and the appropriate help. We took 78 new complaints and 23 of those were housing. We also closed 26 housing complaints, so complaints that carried from one year to another. They're typically not that long, typically 100 to 150 days or less. And we've participated in over 20 educational and collaborative projects to help educate. So we provide education for housing providers and for tenants about their rights here within the city of Pittsburgh. And I think that's all the slides for me, Jim.
Yeah, thanks, Rita.
Yeah, again, when in doubt, check us out.
Absolutely, yeah. And you can find my email in the chat. You can contact us a lot of different ways. Most of the phone numbers for the commission eventually lead to me. So if you do need us, you can reach out to me and you can get me that way. You can get me by email, by phone. Yeah, and so now we're going to talk a little bit about some of the resources that are available here in the city of Pittsburgh. The first one that we're going to talk about is Rent Help PGH, and we have Abby Ray on to talk about that.
Yeah, thanks, Jim. Hi, everyone. My name is Abby Ray Lacombe. I am with Rent Help PGH. And as quickly as I am able, I'm going to run through some of the larger rental assistance programs and rehousing assistance programs available to residents of Pittsburgh proper and Allegheny County. Jim, do you want to? Thanks. First, we're going to run through some housing opportunity fund programs. These are oriented toward Pittsburgh residents. So not just Pittsburgh as your mailing address, as we are all accustomed to seeing, but actually in the boundaries of Pittsburgh proper. HSP can provide up to $3,000 or 3 months for back rent or utilities. It does require that you have a valid lease. It also requires that you are able to show that you will be able to pay the rent moving forward. So this is a great program if you have fallen behind, but since found employment and you know that once you get caught up, you will be able to keep that going. These programs also require that your landlord is up to date on their property taxes, though that's not a detail that I want you to worry too far about. It can cover first and last month rent or a security deposit as well if you are looking to move or have been facing an eviction and would like to get prepared to take the next step into a new unit. For first and last month rent or security deposit, it will require that you have a rental agreement or a lease already signed with your prospective landlord. And to access HSP, you will call 211. And I want to emphasize right now, they are busy. And so if at first you do not succeed, call again. It can take a couple of days to get through. There, as we know, being in this webinar right now, there's a lot going on and a lot of folks in need. Jam, you can go to the next slide. So this program has about 1 million names, but I like COVID-19 HSP, and it basically has the same perks of the HSP that we just discussed, as well as mostly the same requirements in that you do have to be a Pittsburgh resident and have a valid lease. The one exciting thing about COVID-19 HSP is that it does not require that you are able to pay rent moving forward. This is really there to help support people who have been impacted by COVID-19 and ensure that you are able to get out of a hole if you are finding yourself arriving in one. And again, this is going to be accessed through 211. Jam, you can go on to the next one. And then our third city program is called the Eviction Prevention Program. As with HSP and HSP COVID-19, it does require that you live in Pittsburgh and have a valid lease. This program also requires that you have an active eviction against you. So that would require that the magistrate has sent you the notice and that you have a docket number. This program is kind of excitingly flexible, though, in that it can help you settle up your rental arrears, as well as help cover supersedious payments, which are the rental payments that you pay to the court during an eviction process. One string with the EPP is that your landlord will need to agree to cease the eviction proceeding. And for this program, you're actually going to reach out to us at Rent Help PGH. And our phone number is listed there, 412-534-6600. Jam, you can go on to the next slide. Now we'll branch out to county-wide programs that are available. And I'm gonna, before I dive into this, I think a lot of folks on this call are likely familiar with the CARES Rental Relief Program that was in place between July and November and is wrapping up right now in terms of getting those payments out. The RRP was a really great program because first off, the income requirements were quite high. It was 100% of AMI for households. It was very flexible for a lot of residents, and the application deadline was November 4th after an extension from October 31st. Or excuse me, September 30th. I apologize. At this point, there is not that level of a flexible program available county-wide, nor statewide for that matter. But I want to emphasize that people are working on this and they are working really, really diligently. There are pockets of people at the state level, at the county level, and even within the city who are trying to figure out what we can scrape together to get broader more preventatively oriented rental relief programs in place. There's nothing hard and fast right now, but what I want to emphasize here is that this is a changing landscape, daily, weekly, monthly. And so if you do not live in Pittsburgh proper, and you see that you will not qualify for the programs that are available countywide, please don't lose hope. Please give us a call at Rent Help PGH. And you can call us frequently, because as these programs are evolving and changing, what you don't see available right now could very well become available in the next few weeks or couple of months. So countywide, we have the Emergency Solutions Grant, which requires that you are at 30% of AMI. To give you an outline for that, that's about $17,450 for a one-person household, and for a three-person household, that would look like $22,450. So it is kind of a tight requirement in terms of your household AMI. It also requires that you have an order of possession, which is basically a finding for the plaintiff, who would be the landlord in an eviction case. One of the great things about ESG that I want to emphasize, though, is that there is no cap on the amount of money that it is able to pay out, though the landlord still must agree to a third-party payment. To inquire about ESG, you will call Allegheny Link. Their telephone number is listed at the bottom of this slide. It is 866-730-2368. And I, again, just as with 211, want to emphasize that they are fielding lots and lots of calls. And so if you don't get through on your first try, please be consistent. Jam, you can.
We had a question that maybe is good for this section in the Q&A. Someone asked, are you saying in order to qualify, my landlord has to be up to date on property taxes? And how would they find that out if that is the case? Do you happen to know?
So for some of these programs, yes. You can use the Allegheny County Real Estate Portal to check on local taxes. You can also call us at Rent Help PGH, because the Allegheny County Real Estate Portal can be a little confusing to learn. But I will definitely make sure that link goes out with the follow-up information. But again, I don't want to encourage anyone to screen themselves out of programs. Call and talk with us first. I don't want you to ever assume that you will not qualify without getting some advice or guidance, because even if you find that you will not qualify for one of these programs, this is not the end of the road. These are just the broadest umbrellas of programming that we have. The reality is this landscape in Allegheny County is always changing, even without a pandemic. What you see as available to you right now through this, right, Allegheny County-wide or Pittsburgh proper, does not show you the various organizations and programs that are very group specific or very geographically specific, because to get into those is a long list. So don't worry too much about the exact qualifications. I encourage you to call Rent Help PGH, and we can talk through and get a far more comprehensive idea of your situation and dig deeper into what programs might be available to you. I think this is the last one I'm going to dive into for countywide, is the Homelessness Assistance Program. This program is interesting in that the most broad sense that we think about it is for folks who are currently the HUD definition of street homeless. So they are literally on the street, not crashing on a friend's couch or staying in a hotel, or those that'll be facing homelessness after release from the hospital. However, it also has the ability to support people who are fleeing domestic violence, facing natural. I'm going to ask Richard Morris actually to jump in on this, because he gave me a handful of extras there. It's impacted by natural disasters, or what were the other ones for this, Richard?
Community violence. You can also be receive assistance if you're working with the Red Cross for, let's say, for example, you are involved in a fire, there's a large gas leak and people have to relocate. The property has to be demolished. There's been a landslide. people are assisted through this grant based on a referral, typically either to Allegheny Links or the Red Cross.
Thanks, Richard.
Yeah, community violence comes through another program that is run by Richard Garland. And when those situations come up, you get a referral through that agency into the links.
And so I just wanted to bring this one to folks' attention because I feel like it illustrates the complexity of the rental assistance programs that are available, especially at the county level, and highlights that what you think you will qualify for oftentimes has more nuance than you will be aware of at a single reading about the program, which is why it is very important. Reach out to us. And in fact, Jim, I think you can go to the next page or slide. Please do reach out to us, reach out to 211 and Allegheny Link. One of the things that sets Rent Help PGH apart is that we have the time, we try to spend the time with you to really dive into the nuances of your situation and work with you to identify the best pathways and the broadest pathways available to you. I also want to add in that we do have a Spanish speaking line through the Pittsburgh Hispanic Development Corporation, and I will put that number in the chat. And that's all I've got. Cha.
Sorry, I didn't unmute myself correctly. Yeah, thank you so much. There is one question, and then I think after that would be a good time for Richard to speak a little bit if he has anything to add. But somebody asked, my boyfriend's kids stay with us 2 days a week, and the rest of the week they're with their mom. Would we count as a household with minors even though they don't live here? I think this is probably a question for you, but I can answer if this were a familial status discrimination complaint, then it would count for us. But I'll let Abby Ray, you answer this if you have an answer.
For all programs that I'm aware of, partial custody of kids, like having the kids in the house a few times a week, counts as having minors in your household.
I would concur.
Thanks. And then Richard Morris is from the Urban League of Greater Pittsburgh, who has really done a whole lot of housing work here in Pittsburgh. Richard, do you have any things that you wanted to add on here to our resources section?
Well, the first thing is that the Urban League of Greater Pittsburgh is involved with pretty much all of the programs that Abby Ray mentioned. We also do mortgage foreclosure through the Save Your Home program, which is operated by the Allegheny County Courts. I do want to explain at the top that for us, we don't receive referral directly. We receive referrals from 211, Allegheny Links, and Save Your Home, so that although we can help you get to where you need to go, the referral comes back from one of those agencies. In terms of dealing with resources and housing, there are a couple of things that I want to say to folks who are beginning this process. The first is understand that the most resources or the most direction that you're going to receive is at the Links, Rent Help Pittsburgh, and 211. A lot of times people will call us and they say, I have a list of 34 agencies that I'm looking at. And we always say, hey, Rent Help Pittsburgh, 211, the Links, and if you're a veteran, the Veteran Leadership Project. So when you make the calls, you want to be clear about what you want. And if you don't know what you want, you need to be able to tell your story to the person so that they can understand what your need is, so that the referral can be quickly addressed. The second is that you have to understand that there are some documents that we are going to be seeking from you to either verify custody, to determine who you are, And most importantly, we want to talk about who, in terms of who you owe, why you owe, and how we can get in touch with that person to get a ledger or something of that nature. The other thing is that when you're contacted and someone calls you, please respond. Most agencies have a time period in which they contact you, and after that period, they send you a denial of service letter. So do respond. If you have multiple ways that you wish to be contacted, put those down so that they can utilize all those models or methods to get in touch with you. And when they do contact you, please make it clear that either you have time or you don't have time. If you don't have time, they'll reset another appointment for you, but make sure that you understand that it's going to take you about an hour to get through the process. When the initial intake occurs at the United Way or 211, I'm sorry, United Way or Allegheny Links, it's going to take you about 30 minutes. But when you begin to interact with an agency, it will take a little longer, primarily because they're trying to get all the facts, make sure that they have all the paperwork before they start contacting your landlord. The other important thing is to be as truthful as possible. If there's some deal that you've made with the landlord, tell us. If the landlord is putting you out for some other reason, tell us. And if you don't have the ability to pay, when we sit down and go over the budget with you, make sure that you understand that the goal is to help you sustain housing. And if you can only afford $800, but you're paying for $1,500, then we want to try to create a solution where your housing is stable. And the last thing is that there are things that are beyond your control. As Abby mentioned in some of the programs, you can't force your landlord to pay his taxes. You can't necessarily force your landlord to have the house meet what's called HQS, housing quality standards. So if there are broken windows, steps that need to be repaired, holes in the wall, that will not be a unit that these dollars will support. And the landlord will have to fix the house up. But again, that's not your issue. That's something that we handle as part of the process. The other thing is that the payments will go to the landlord in a timely manner. And for most of us, there's a document that he or she or the company agrees to sign, which says that they will not evict you for 60 days. And then sometimes there are conditions that we place in there, which says that, the tenant is going to do X, the landlord is going to do Y, and we all agree to it together. And we make sure that if there's a payment plan, that it's one that you can afford. Finally, is that always be ready to make a decision about what you want. It's not what we want. It's not what the landlord wants. It's what you want. On our side, we will tell you realistically what we can do, how you can make it work, and what other things that you need to consider. But always remember the final decision is yours. And if you're not comfortable with it, we encourage you to contact Neighborhood Legal Services so that, they can assist you if you've got a legal issue that you're unclear about. So that's what I got, Jam.
Thanks, Richard. Yeah, that's really helpful. One thing that came to my mind also about Urban League is the Operation Home Workshop, which could be of interest to those who have Section 8 vouchers. The Operation Home Workshop is a home ownership workshop that focuses on um, changing your Section 8 voucher from a rent voucher to, I believe, a mortgage voucher, and creating a pathway for people who are renting to become homeowners. Richard, you can correct me if I said any of that incorrectly, but those workshops are held once a month.
Yes, they are. And thank you, Jam, for mentioning that. The other thing too is that we do have an emergency food pantry. so that, if you're in a situation where you need food for your family, we are a pantry of last resort and can get you to the point of where you're connected to a regular food pantry. We find that sometimes issues relating to housing in terms of rent also deal with issues relating to food, and we can support that.
Thanks, Richard. I didn't unmute again. So I think our last speaker is Aaron Erb from Just Mediation Pittsburgh. This is a newer service and not everyone knows to use it, but it's a really important one now, especially that we can see the end of the eviction moratorium barreling towards us. So I'm going to turn it over to Aaron.
Yeah, wonderful. Thank you, Jam. Good to be with you all today. I'm going to move through this as quickly as I can to be able to describe our services at Just Mediation Pittsburgh. So you can proceed to the next slide, Jam. Essentially, Just Mediation Pittsburgh offers mediation services for you as renters to be able to resolve disputes with your landlord or your property manager as soon as possible when conflict has started. We work best at the point of conflict and not 6, 9, or 12 months after things have really started boiling, but we will work with those cases too, of course. So we offer a free, confidential, voluntary process where a neutral third party called a mediator will work with you to help you and the person that you're in conflict with, your landlord or your property manager, find some kind of a solution that can hopefully satisfy both of your needs in the conflict that has occurred. So we're here to help you all state your case clearly. Our mediators are trained to do that, to help you and the other person involved listen to each other in the ways that I at least struggle with when I'm in the middle of my own conflicts, to be able to really come up with a solution where you and the other person at the table have as much say as possible in how the situation will be resolved, instead of relying on a judge to be able to make a decision in your case. If you come to mediation, you have a fair amount of power in shaping the outcome of an agreement that you come up with. So the end result of a mediation is hopefully to come up with an agreement that is legally binding, that you and the person on the other side of the table has shaped together. So Jam, if you can move on to the next slide. We have a pretty simple process, which is that we receive a referral online or by phone. Our website, justmediationpgh.org, is the best place to make a referral. Either landlords or tenants or third-party community organizations can make referrals. You'll fill out a very quick questionnaire about what's happened and who you are. And we work especially with folks who make under 80% of area median income. I believe for a single person, that's around $45,000 a year or less, and it increases as you have more people in your household. Our staff will make a phone call to you as the referral source if you are the tenant making the referral. And once we've talked with you to make sure you understand mediation and the fact that this is a voluntary process where you get to meet with the landlord to be able to resolve your dispute, we will then give them a call with your permission to see if they're interested in mediation as well, as a way to save money, to come up with more sustainable agreements that everybody has a say in shaping together. And if everybody has agreed to come to the mediation table, then we assign community mediators, people who have been trained from the community to mediate these cases. And they will call you individually, the landlord and the tenant, to get a better sense of what you're hoping to see happen from a mediation. And then we'll set up the mediation. Right now, we are mediating fully online. So our program would send you a link to a Zoom call to be able to participate in a mediation. We usually set aside up to 3 hours for mediation, but so far, only 1 or 2 of our mediations have taken that long. We found that a lot of the preparatory work that we do helps people to get to a place where they're ready to get things done, make decisions. And this is really something that operates with a little bit of good faith, that people are coming to the table because they want to find solutions, because they have really specific needs, but also because they're trying to come up with a solution that allows them to stay in their home and allows a landlord to keep providing housing and to keep on earning money from rent with that housing arrangement. So mediation can take up to 3 hours, but usually is a little less. And at the end of that, the parties will come up with a legally binding agreement that they have shaped themselves, that the mediator has helped them to write. Everybody gets a copy of that. And then our program will follow up with you a month and 3 months later to see if the agreement has held and if you needed any support with that. And we work with other organizations such as Rent Help PGH and the Urban League to be able to make referrals if you as the tenant or the landlord have wanted to seek something like rental assistance to make your agreement sustainable, or food security, all sorts of different resources that you might need. Next slide, Jan. So this is a quick list of when you might want to choose mediation and what the benefits are. And I've already mentioned these, so I'll just really quickly highlight that mediation is free. It's voluntary. It keeps your conversation private, but lets you come out of it with a very specific agreement so that everybody involved knows exactly what each person has committed to doing to be able to resolve this housing dispute. You're going to want to choose mediation if you've got a dispute with your landlord, whether that's a social issue, whether that's a non-payment issue, whatever it is. If you think that you can come to the virtual table and talk about what has happened, listen to your landlord do the same, and then take where both of you are coming from to come up with an agreement together, then mediation is definitely the right choice for you. Especially in this time of eviction moratoriums, oftentimes mediation can be faster than the court process where things are getting delayed at this point, to be able to come up to a resolution and have this cloud that's been hanging over your head lifted a little bit with the help of a clear agreement. So I have our contact information at the bottom, and we can maybe share this in the chat again as well. The best way to make a referral for mediation for yourself or somebody that you know is through our website, justmediationpgh.org. You can also call us at 412-228-0730 to make a referral, but the website's the best way to reach us. Next slide, please. Last thing I want to highlight really quickly, I mentioned we use community members who have been trained to mediate these cases. And that's because it's important for us to be building capacity in our communities that we all live in to be able to resolve conflict successfully. And in this eviction crisis, it's no different. So we have an upcoming training at the end of January, beginning of February, and you can see the times listed here. If you or somebody that you know is the kind of person that people turn to help find clarity when they are in conflict or help resolve conflict situations, then you are probably a good fit for our mediator training program. So this is a 40-hour mediation training over these 2 weekends in January and February. And if you participate in this and complete the training, which is free as well, because we want anybody who has these skills to be able to access this through an application process, then you can receive a small stipend for mediating these cases, because we want to make sure that folks can essentially volunteer their time, but get a little bit of compensation for that time, because we value your skills and your input. So if you're interested in this, again, visit our website, justmediationpgh.org, or you can email our mediation and engagement director, Brenda Harris, or give her a call with the number listed here. And we'd love to receive your application and be able to see if you'd be a good fit for mediating these eviction mediation cases. That's what I have. Happy to answer some questions and turn over time for my panelists, my co-panelists, to answer questions as well.
Yeah, and if anyone has any questions outstanding, I know we have maybe like 5 or so minutes left, but if anyone has any questions outstanding, please, put them in the Q&A or in the chat. We've had a lot of great information shared here, and we'll be sending a follow-up email to everyone who registered with some of these resources listed and with the slides, so that you can have them for whatever time period you'll need them. If you have any follow-up questions, you can contact us at the commission. I left our email, which is human.relations@pittsburghpa.gov, or you can contact me directly for anything related to this or housing discrimination at jam.hammond@pittsburghpa.gov. If you perhaps need us to send this information to another person or anyone else who would need it. Um, Someone asked for mediation training. The time ranges to not less than AM or PM for the starting hour. So is that then the first for the mediation trainings, Aaron, is it January 22nd, 6 a.m. to, or I'm sorry, 6 p.m. to 9 p.m. and then
Yes.
the other days are 9 a.m. to 4 p.m.
Yes, I hope that these are at relatively human hours for everyone. So for both weekends, it's a Friday evening and then a Saturday and Sunday all day. So Friday 6 to 9 p.m. and then Saturday and Sunday 9 a.m. to 4 p.m. both days.
Yeah, it's really cool. And so is this, I think you mentioned it, but is this looking for somebody with any kind of mediation experience, or can this be, anyone, even if they haven't quite done mediation training before?
Good question. No mediation experience required. We ask questions in the application about why you want to be a mediator and what kind of background in resolving conflict, and also in working with folks from all kinds of backgrounds you have that you would be bringing to this experience, because we are looking for a mediation pool that is able to work with all sorts of people from all kinds of backgrounds. So if you have skills in that area and you're the kind of person that people turn to in conflict, you are a great fit for this program.
Yeah, I think that's a really cool, great opportunity for someone, I know people tend not to have time and everyone is struggling to make life work, but it can be a very fulfilling thing to provide the service to your own community. And I think it makes mediation that much more meaningful, and mediation requires a lot of trust for the parties who enter it. So it's really meaningful when we can have um, people come in. I don't believe so. Someone asked in the Q&A, are there charges? I don't believe so. Are there charges for the mediation services? Aaron, that's correct, right?
That's correct. No charges.
Yeah. And yeah, if anyone, of course, if you have any questions after this, oh, someone asked one last thing. Does Just Mediation work with case managers from rapid rehousing programs to resolve conflicts? That's interesting.
So we have gotten referrals from folks like Goodwill of Southwestern Pennsylvania. I'm forgetting a couple organizations too. And when that has come from case managers, we've been able to actually include them in the mediation itself, because they're a tremendous resource for the tenant, of course, but also for the landlord, because everybody at the table wants a sustainable long-term agreement. And so if you have the resources necessary to make that happen, all the better for everybody. And we work with Rent Help PGH to make referrals after the fact, and the Urban League as well, and a variety of other partners as well. So we like to make sure that folks are included in the mediation process if both landlord and tenant are willing for them to be there, and if they will be a positive resource to creating a sustainable agreement.
Thanks. And here's a question that's just for me. I know for the commission, when somebody files complaint, they can designate somebody who is not a lawyer but is their non-legal advocate to represent them during the commission's process. Is that something that you can do for Just Mediation as well?
Yeah, good question. Essentially, what needs to be in place is for all of the parties coming to the table to consent to who's going to be there. So whether it's an attorney or not an attorney, as long as everybody consents to their presence, we welcome them to the table. And what we want is the conditions for like the chance to have a creative conversation about how to resolve these disputes. Sometimes, especially with the cases where it's kind of a social issue that has gotten in the way of this relationship between landlord and tenant, folks need to be ready to think of new ways of being together to make this relationship between landlord and tenant work. And so as long as folks coming to the table are in that spirit and in that mindset of how are we going to resolve this so everyone can be as satisfied as possible, then we'll welcome them at the mediation table for sure.
Great. And I think if anyone has any follow-up questions, they can also send those to us at the commission. And when we get those, we can pass them along to our panelists if it's something that someone at the commission can't answer. We're happy to stay open and available to make sure that the community gets what they need in terms of understanding these resources. There's a lot. I know this presentation covered quite a bit, so if there are follow-up questions, don't worry about reaching out to the commission or to any of the organizations that the contact information that they provided in the chat and that you'll see in the emails. So once again, thank you both to the attendees and especially to the panelists for coming on and talking about all of the resources that we have here in Pittsburgh and the ways that people can get their needs met in housing, whether it's fair housing rights or utility assistance, legal assistance, rental assistance, and mediation. I think all of these are extremely important, and I'm so glad that we've been able to have this great group of panelists come on. So thank you to everybody. I think we will end now. I know that we're about 2 minutes past, and everyone has their work to get back to, which of course, as we've seen in this presentation, has been so important. So thank you to everybody. I'm so glad everyone could be here.